has stated the source of the information. She has stated the source from each single body that she has mentioned who has not deposed an affidavit in this court. Or every person she in any paragraph rather has deposed an affidavit in this court, and the record reflects that. Decisions are bound by law. If she states where she gets information from, and the person who she's getting information from is not before court by way of an affidavit, that's the only way you can call it hearsay. But whereby she states that Caroline informed me and saying Agent Caroline is here with an affidavit, that ceases to be hearsay. And all of those affidavits of persons she referring to her affidavit are before this court by way of affidavits. Now, my Lord, I also tend to think that we are reading from different decisions of Petition 7. But in that case, yes, it was part of the new decision. Here that I should, however, comment especially on affidavits under 4.7 and 83A of the election petition rules to accompany the petition and answers there. The same rules require that those affidavits shall set out the facts on which the petition is based, and the respondent will rely on as the case may be. However, the parties have relied heavily on factual information they receive from their agents and other witnesses in order to comply with that requirement. In my view, is what Mulenga says, in my view, therefore, in relation to those affidavits, those affidavits, Order 17 Rule 3, which I think back to now is 19, of the CPR has to be applied with such modifications as permits the petitioner and the respondents to include in those affidavits facts which they hold on such information. And that decision was referred to by the Court of Appeal in the case of Mpanga, Farouk versus Sembuge Isaac, and I'm reading from that decision. After quoting all of that, my Lord, the Lordship said in the Court of Appeal, after quoting that part of the decision, that in the instant case, a reading of paragraphs 5A to M of the petitioner's affidavit, just like in this case, my Lord, shows that what was stated therein was information based on what was provided from polling agents and supporters, as in this case. The petitioner, the Lordship said, the petitioner clearly disclosed the sources of his information, who also saw affidavits in support of the said allegations based on their knowledge, as has happened here. Then they held their lordships in Ssenyonyi, last round of elections. They then held, we find that the learned trial judge found that the disclosure of sources of information by the petitioner was sufficient, following the majority decision in Kiza versus Museveni. That was the holding of the lordship. It's not hearsay. My Lord in Muhindo, Rehma. In Rehma versus Winfred Kiza, EPA number 29 of 2011. The lordship said that in these cases, the candidates rely on appointed agents, and as such, should have included that specific source of information, as has happened here, in the affidavits, or else they file separate affidavits from the agents who witnessed the occurrences. That's what we did, my Lord. And the lordships then held that the learned trial judge cannot be faulted over this aspect of the matter. So my lord, our submission is that first, the evidence act relied on doesn't apply to the evidence. Two, the petitioner has disclosed all sources of information. Three, those persons from whom she has sourced that information have all deposed their affidavits and they're on court record. Number four, then their lordship said that ceases to be hearsay. Also, my lord, the candidate is not expected to be in each polling station out of the 197. She relies on information from supporters, from campaigners, from agents. It's only hearsay if she says, Musisi told me this, and there's nothing that Musisi. If that the case is, the affidavit is there, that ceases to be hearsay. I'm obliged, my lord.
Yes, my lord. For starters, whereas it's true that all these witnesses deposed affidavits and that they disclosed information that may be the guide. Our submission is not premised. I use the word elementarily, the principle in section 59. Elementarily is cardinal. Evidence has to be evidence of so. But our submission is rooted in Order 19.3, 1 and 2. My lord. We submit that hearsay evidence is prohibited. Even belief is prohibited under the law. The issue of information received is prohibited. It's our submission under Order 19. Rule 3, 1 and 2. My lord, why I raised this issue at this point? I was finding difficulty proceeding with the agents who are ready to question. They disclosed evidence information that she does not have, my lord. To rest this point, my lord, that is why it would be very proper that we expand those paragraphs because how then why go there? Then why go there? When I already have a ruling on record that you cannot cross-examine them. That's why I raised it at this point. He's telling me they are there. I cannot access them. The witness is saying, I don't know, I brought witnesses. It was from her evidence. So I'm at pains, my lord. I would not have praised it with petition. So I pray. My lord, and these cases, most of them somehow both sides participated, are read themselves, and we know they are distinguishing. My lord, to distinguish them properly, since my colleague submitted in the authority, just for distinguishing purposes, the rest of us more right.
My lord, the decision has referred to bring me back to my lord. The decision has referring to Justice Odo in the 2001 election. My lord, this is, I need to really offer a proper context of why, where you're using affidavits, the courts are very strict on what can be admitted. Also from the side. My lord, in election petitions and constitutional petitions, the only way by which you can bring evidence into affidavit. My lord, the case goes further to state that hearsay, or what we can categorize as hearsay, would only be admissible in interlocutory matters. Say if I have suit and I want to get an injunction, then I can go to my lawyer, and my lawyer informs me that that plight discloses prima facie the case, and therefore I qualify to be given an injunction. My lord, that is the only way you can have hearsay evidence admitted on record in interlocutory. And my lord, it does not help, especially for the petitioner, to bring paragraph 23. If Mr. Kalule read the decision that I read, he knows that was the contention, that all the affidavits that they sought to strike off the record had that statement, that what they have stated, we have disclosed the sources and belief. And court said, no, we cannot nullify or confirm a candidate of an election on the basis of one, belief, two, information that is sourced from another party. That is, my lord, the rationale. But my lord, I read the excerpt. It says that, this is from Semogere, it says that except in purely interlocutory matters, affidavits must be restricted to matters within personal knowledge of the deponent. Two, they must not be based on information or by expression of opinion. It goes on, my lord, affidavits should strictly be confined to such facts as the deponent is able of his own knowledge to prove. Affidavits by persons having no personal knowledge of the facts and merely echoing the statements of the client cannot be used at the hearing. This is where we are. Hajat Nambi says Nalukoola is not a duly elected member of Parliament. What evidence must court rely on? Hajat Nambi was told by her lawyers that there was non-compliance. Lawyers, the election was marred by great violence that affected the results in a substantial manner. She does not have that knowledge. She is quoting other people, my lord. That is inadmissible, my lord. And that is, so my lord, the issue of Court of Appeal, High Courts, it is really, Mr. Kamle has an affair with it. But we have a Supreme Court decision. And my lord, we cannot go behind. We cannot go back, my lord.
I know that was Celine, disenfranchisement and the rest, you can go to illegality. Agents, Nambi. Let's go to paragraph 16. That's where we start now. It's a hearsay. I don't have to go to it since if it is said otherwise, not that I believe it. 16 one, is it your testimony under 16 that Gordon Saleh informed you that the first respondent campaigned on the polling day by saying Yenze Nalukoola. Yenze Nalukoola. Is it your evidence?
Yes, my lord.
Is Yenze Nalukoola a campaigning statement? Yenze Nalukoola, is it a campaigning statement? Qualified. That's 16.
Yes, my lord.
Nambi, when you arrived at the polling station, you took us through. Is your statement that you would mention your name? That you arrive at the polling station, Nambi, a check if you're a registered voter. Did you mention your name when you arrived at the polling station? That mention of name, would be right to state that you campaign at the polling station? Premier.
My Lord, attached my codon clearly states that
You, Nambi, you are the one who was there. You said you went there with your husband. Did your husband state his name? Says you. Did your husband state his name? Would we be right to state that your husband campaigned for you at the polling station?
no, my Lord.
And where is the evidence? It's a matter of evidence. It's a court of evidence. Where is the evidence that Nalukoola, is it anywhere, appeared at that polling station as stated? I've seen in your petition pictures, photographs, what? Do you have any such evidence? Yes or no?
My Lord, as per the affidavit that's correct, that is, and
You have.
the affidavit details, that's how it came to this.
No, you are not there, you are not there. That supporter may not come to court with that evidence on the face of it. I beg you, lawyer. Is it there, yes or no? So that's the rush. Is it there? It's a yes or no? Okay. Are there names of persons that he influenced as per your statement? Say these campaign statements to influence. Are there names of such people? Are there names? Yes or no? Of voters in your petition?
The names of the voters are not included.
Are there numbers?
Stations,
The names are
but
not
the
there.
polling station is mentioned.
The names are not there. Are there numbers? Was it a crowd? Are there numbers in your petition?
He campaigned, my Lord, the first
Are
respondent campaigned
there-
among the voters.
Are there numbers? Simple. There are numbers or not?
No, my
There are
Lord.
no numbers. Would I be wrong? Is it possible that Gordon Salim Saleh is an NRM supporter? Is it a possibility? Gordon Salim Saleh. Is it a possibility that he can be an NRM supporter? Or is he one?
Yes, my Lord.
Yes.
It's a possibility.
So, would he then be your supporter? By being
My Lord.
NRM, would he be your supporter?
My Lord, that is not ascertained in the
Would he
affidavit.
be?
But if he were an NRM supporter,
Yes.
he would be my supporter.
So would I be wrong to presuppose, not saying you know, to presuppose that he may have voted for you?
No, my Lord.
Presuppose.
My Lord, I object to that question. In the advancement to an election petition, a question cannot be asked as the choice of a particular voter. That's barred by Section 102 of the PA.
Let's move right. Would you ascertain? You said polling station. Would you ascertain? Within how many meters? Within how many meters? You said polling station is open. If Nalukoola was there. The parameters. distance between where he was standing. I don't think he was in the ballot box. The distance, would you ascertain, yes or no?
The distance between where he was, is that what you answered?
Yes. Because the state polling station stated means communication.
My lord, the detail I captured in my affidavit is of the polling station, which is KKTv.
So you cannot ascertain the distance because it's important. You cannot.
No.
No. So then, do you have any evidence or any report from your purported agents? The report about this campaigning at the polling day and how it happened? The report.
My lord, yes, my lord, I do have.
You have the report. Is it before this court?
I have an oral report, as I have stated in this affidavit.
You do not have a formal report. Okay, let's go to another element. Again, paragraph 16. 16.2 particularly. Telling voters amaanyi g'abantu temugalyamu olukwe. He said, literally translated, do not betray people power. What does amaanyi g'abantu mean?
The efforts of the people.
The efforts of the people. Does the efforts of the people mean Nalukoola? Don't betray the efforts of the people. Does it mean voting for Nalukoola, according to you?
My lord, in this paragraph 16.2, page 014, it goes on to say, do not betray people's powers. So it's not in isolation.
This is what was stated here. Does this mean Nalukoola? These are specific illegalities, even one can have a problem. An allegation. Did it mean Nalukoola? Does it mean efforts of people? Does it mean? It's about your interpretation. If someone said it to you, or to say it to someone, will it qualify? I'm obliged.
16.2.
My lord, I have a question on every electoral offense.
At 16.2, my lord, it is yes attributed to the first respondent campaigning among the supporters on polling station in Kazamba.
My question, it's about my question. Does it mean vote for Nalukoola? Mani government said you don't know.
My lord, as stated in 16.2, it means vote for people power, and he was the candidate for people power.
Oh, so Nalukoola was a candidate for people power. No, he's not here. Is it your statement that people power sponsored the candidate?
My lord, I meant to say that this was attributed to the first respondent campaign.
So people power did not sponsor any candidate?
My lord, people power is not encourages that party.
Yes, 16.3. 16.3. Do you have proof that the first respondent had agents by the names of Kibirige as stated in 16.3? Names of Kibirige Musa? Yes. Right.
So the matter is stood over till 2 p.m.
Abantu nga baweddeko nnyo. Tekuli muliro. Yes, ekigenda maaso sawa zino kooti etuwumuzaamuko paka sawa 8 tugenda kukomawo ate era tuddemu buto. Hey, mba kusimu yange.